Hello, Andrzej Bojarski here, together with Rhys Taylor. Rhys and I are currently confined to barracks, as millions of others are, as a result of the coronavirus epidemic. So we've decided it might be useful just to have a recording every week or two, just to catch up on a few issues that have arisen and are arising and are troubling people. And so we've decided to pull up our armchairs around our virtual fireplace and our virtual library, as you can see, and have a discussion about something that's close to our hearts. Both Rhys and I, as many of you know, are very keen on various kinds of ADR and out-of-court dispute resolution. So today we thought we'd discuss private FDRs. Hi Rhys, how are you?
Yeah, morning Andrzej. Well, thank you at the moment.
Jolly good. Let's hope it stays that way. So Rhys, any thoughts? Do you want to kick off?
Yeah, well, there's been a real increase in private FDRs in the last year or two. What do you think prior to the crisis have been the drivers for that?
Well, you're right. I mean, there really has. I mean, I don't know whether your experience has been the same as mine. I mean, I had months last year where a whole month went past without me going into a formal courtroom at all. All the work was being dealt with by way of private FDRs or arbitrations. And I think that's been largely because of the under-resourcing of the courts over the last few years, even before the pandemic struck and created the difficulties we've got now. There were difficulties with cases being listed at very long distances from the time when they were set down. There weren't enough judges to deal with the cases in a timely fashion. Judges' lists were too long, so judges weren't able to give a case the amount of time that it required to properly get in under the skin of the case and give a proper indication. The court buildings themselves were not conducive to settlements where people couldn't find a space to speak privately and didn't really have the time to do it. And you just didn't know who you were going to get as a judge. So if you had a particularly complicated case with trusts or companies, pension issues, offshore trust issues, you didn't have any guarantee that the judge you got had any particular experience or expertise in dealing with those sorts of cases. So as a result, people were getting indications at FDRs that they weren't confident in, weren't able to accept, and so they were looking at a better way of doing it. I think that's why the private FDR very much grew up. And that was very much reflected in the settlement rate, which in private FDRs, as you know, quite often, certainly in excess of 90%, close to 100% settlement rate, which speaks volumes for the quality of the process compared to the court alternative. So that's what we're seeing happening last year. I mean, do you think that's now going to change as a result of the current circumstances we're going through?
Well, I've watched in alarm, as everybody else has, and let's put it in context. There are bigger issues in the world at the moment than sorting out divorce settlements, but they are important for people who are anxious to have resolution. So I want to get the perspective right in the first instance. But having set that perspective, I've watched in horror, particularly on Twitter, seeing different reports coming in from around the country as to how really the court system is melting down. Now, this is not to criticise in any way the efforts of the court staff. This is an absolutely unprecedented incident. And what I'm saying now is not meant critically at all, but many companies, many institutions are simply melting down under the pressure of things having ground to a halt. We've seen a very impressive document from Mr. Justice MacDonald about the remote access family court, which we're going to talk about in a moment.
Yeah.
But and a very interesting comment from somebody who describes himself anonymously as Judge Itis on Twitter yesterday, and he was saying it's all good and well having this great protocol in place, but the reality is at the district bench, where a lot of our cases get resolved if they're in court, is that they have back-to-back listing for the rest of the year. And if one just pictures for a moment the typical day in just about any court, if you're in the FDR list, there'll be perhaps 5 or 6 FDRs listed back to back for the day. You might be listed at 10, you might not get in maybe until 12, you'll have your 40 minutes, and then you might check back in with the judge at 2:30 in the afternoon, either with an update or seeking further refinements in the indication that's been given. And the raw logistics of trying to get that kind of list managed when, as we'll mention in a moment, the court system has profound challenges with its IT. And again, absolutely no disrespect is intended in saying this. People aren't appointed to judicial office because they're IT geeks, but there'll be many judges out there who aren't comfortable or just used to working paperlessly and working remotely. And so really we have this absolute crisis now as to how cases generally are going to be resolved. And you and I, obviously, we enjoy our work, but it's got to take its place in the queue, and it's going realistically going to take its place in the queue behind public law children, issues about people losing their homes and things like that. So whilst our work is very important and profoundly important for the people who are engaged in it all, I foresee over the coming months us not really being at the front of the queue for judicial time and looking at things macroeconomically. That's right. But we still have clients who will want to resolve their cases. And I think this is a moment where private FDRs have the potential to really take off.
Yeah. Yeah.
Now we'll talk about the guidance from Mr. Justice Mostyn about them and some other judicial guidance in a moment. But I'm interested, Andrzej, you're something of a guru with private FDRs. I'm not so lucky as you to have spent several months last year not seeing the inside of a court. But could you just give us a bit of a feel about what an FDR is and how it differs from a court FDR?
Well, fundamentally, it's the same thing. It's, as you know, it's a species of early neutral evaluation, or maybe even not that early. It can come quite late in the process, but it's about appointing an independent, impartial person who in the court system is obviously a judge, but in the private FDR system is somebody who the parties have chosen to give the parties a view as to what would be an appropriate outcome in their case. So from that extent, it's very different to mediation, where the mediator specifically doesn't get involved with giving a view as to the merits. The evaluator's job is just that. It's to give the parties a benchmark that they can use either as the settlement itself or the basis from which they negotiate their settlement. So from that point of view, it's exactly the same as what the court is doing. The differences are really that it can address a lot of those shortcomings that I identified when you asked me earlier on about why there were so many private FTRs becoming popular last year. Because it's not at the court, you can avoid all the difficulties there are with the comfort and privacy. You can hold it in usually barristers' chambers or in a solicitor's office. Everybody is definitely going to have a room. Coffee is going to be available, biscuits, anything else that's required. And there's so much more control. Well, maybe not at the moment, but this, I'm talking about the way it's operated before. And I think we'll talk in a moment about how it's going to look if you're doing it in a remote way. Perhaps the biggest selling point for it is that you've got a judge or an evaluator that the parties have selected. So you know it's somebody who has definitely got the skills and the attributes to deal with the issues in the case, but also to deal with the emotional and softer aspects of a case and understanding how parties negotiate settlements and what they need. So you're guaranteed to have a specialist, and you're also guaranteed that that specialist is going to have the time to deal with your case, because you're not going to be in a queue with 5 or 6 or 7 other cases in the day. The evaluator will read all of the papers. They will be on top of it. They're going to be probing the issues, and you probably have, like I've had the experience where you go before a private FTR judge, and the judge in some respect knows the papers better than you do, and that's always a bit frightening as an advocate, but it shows that you've got somebody who's really properly got to grips with the case, and is therefore going to give a indication which the parties are going to be able to respect. And if they can respect it and see that it's been reached in a really clear, careful and properly thought through fashion, they're far more likely to give it weight than coming out of a court where both advocates turn to their parties and say, well, the judge didn't really get that. And therefore, the indication that's been given isn't so powerful. And then in addition to all of that, you're probably going to have additional services that the evaluator provides that a judge in court just doesn't. You may well get a Duxbury calculation printed out bespoke for your case to back up the figures the evaluator is giving. You may well have a spreadsheet the evaluator has done that sets out exactly the workings that they've reached in order to reach the conclusion. All of it just makes a process that the parties have got a lot more confidence in.
Can I just pick up on one thing that you were saying there about having an impartial tribunal? Mm-hmm. The family bar, in many respects, is a small world, and there may be some nervousness, perhaps, about it being too chummy, and I wonder whether you'd be able to just describe a little bit about the partiality or impartiality and how that works, and what the law is in respect of that. Yeah,
well, I mean, we're not going to get too bogged down with the law in relation to it, but in relation to impartiality, you can be very confident that any person who's offering a service in this way wants to do more of them. They're not just out to do one FDR. And if anyone gets a reputation as not being impartial or being in any way biased towards members of their own chambers or in some way more favourable to people they know than to people they don't, I think in the first place that's not going to happen, but it's also not going to happen because people like that aren't going to be getting work for very long. So everybody who's got a reputation for doing this type of work, like barristers generally, is going to have the self-respect and the professionalism to make sure they do it independently. In terms of the legal aspects, there's certainly no bar to members of the same chambers acting as a private FDR judge in a case in which another member of chambers is instructed, in the same way as there's no bar to them acting against each other in cases where they're on opposite sides. And you expect them to fight them as hard. And as you and I know, as colleagues, quite often the hardest fight you'll ever get is when you're against another member of your own chambers.
As we've done against each other recently.
Yeah, very little quarter was given, Mr. Taylor. So we all know that that's how the process works. But of course, if people are uncomfortable with the perception of it, because often the perception is more important than anything else, by all means, choose an arbitrator or an FDR judge who is not in the same chambers as either of the advocates. And that's not difficult because there's plenty of people out there in the market who can do that. I don't think that's a concern that people should have. And frankly, I've not in any way ever experienced any sense that there's been that degree of favoritism or bias towards a particular person at all.
No. Okay. Well, that's very helpful. Thank you.
I mean, so Rhys, particularly because you do a fair bit of work in London and also, out on circuit, as do I. I mean, what's your general sort of impression of how the judges have approached private FDRs? Are they receptive to the idea, or have you found a degree of resistance?
So it's variable to date. I'm aware in some court centres outside of London that there's a reluctance to embrace them, or at least there was hitherto. The crisis. Quite how people will be approaching it now is another matter. But of course, there are other centres that are very, very receptive and also quite sanguine in the way in which they approach it. So I made some submissions the other day in a case saying, well, we might want a private FDR judge in this case, or provision within the first appointment directions for this. And a very experienced district judge said, I understand what you're saying here, Mr. Taylor. You're worried about this going in front of a deputy who doesn't know anything about family law. I understand your concerns. I just want to reassure you that if this comes back to court for a court-based FDR, I can see it's complicated and I will deal with it. But I have no objections at all if, in fact, you want to go down the private FDR route. So it was a very, very relaxed approach and a very helpful and constructive approach.
Yeah. But of course, we're not in normal times anymore. So I think we're now going to see a different approach, aren't we?
Month.
Yeah.
Another age ago.
Yeah, but of course, I mean, from the top, we've had a fair bit of guidance suggesting already that. This is a route that people should look at taking, and that's only just been strengthened, I think, more recently, hasn't it?
Yes, we have. So If you have a bit of time on your hands over the next couple of months, you might like to dig through all of not Mr. Justice, Sir James Mumby's views from the President's chambers, because he had lots to say about family law. But his last one, as he went out of the door, almost as an afterthought, was about private FDRs. And it was clear he was very anxious before he let go of the reins finally to make sure that he conveyed to the profession how important he thought this was. So in his view on the 27th of July of last year, we had a number of paragraphs which are very supportive of private FDRs running alongside the creation of the Financial Remedies Court pilot system. So from the top, we have that support. And then there was a book published by Class Publishing, the people who do At a Glance, last year, the year before actually, with Miss Justice Bennett, Duncan Brooks, and Miss Justice Mostyn as a consulting editor. And the foreword is written by Sir Andrew McFarlane. And he says, "I stand as one with my predecessor, Sir James Mumby, in hoping that all family judges will take the opportunity to develop and encourage the use of private FDRs." So although not in a formal view, he stands four square with that original view. I think I said a moment ago it was last year. I was wrong in saying that. It was actually July 18. I think life has moved on.
No, you did say it was the year before. You did say it was the year before. Yeah, you did say. Yeah.
And then last year we had the Financial Remedies Court Good Practice Protocol, and at paragraph 10 it says this. I'm going to read it out if I may. Where a case has been referred to be dealt with by an out-of-court settlement mechanism, it shall not ordinarily be given further court time, save for a short directions appointment, which may be vacated by consent in the event an agreement is reached and a consent order presented and approved. Where a private FDR has taken place, the next Financial Remedies Court judge dealing with the case will ordinarily wish to be satisfied that a thorough FDR exercise has taken place, and the party should provide a written explanation to that judge of what has happened, so the FRC judge can be so satisfied. The next bit is important. Absent specific inquiry by the Financial Remedies Court judge, this explanation should not include reference to any without prejudice positions, but should describe the date of the private FDR, the tribunal, the time spent, and an assurance that offers were made and on each side and an indication given. So a number of important points come out of that passage. First of all, it's a clear indication in official guidance that if you have a private FDR, then you're not going to have a judge saying, well, in the ordinary course at least, I'm insisting on a court FDR anyway. You're not duplicating your efforts. And secondly, that passage is dealing with the important relationship between a privileged event, an FDR, which, as we all know from court-based practice, is without prejudice, and then what the subsequent court is able to inquire about. And I understand that both the FLBA and Resolution were consulted about that paragraph and were content that the barest of indications about the nature of the tribunal, the time spent, and assurance offers were given, but without detailing them, was considered to be satisfactory in the circumstances. Now, it does have the proviso, absent of specific inquiry, that no further information should be given. I am aware of some judges who have said they have made further inquiry, wanting to be absolutely certain that this is a case where no stone was left unturned in seeking a resolution before court resources are used in listing for final hearing. And the way in which I'm aware judges have approached it is to say that if they are making specific inquiry, they are in effect under the rules listing in the directions appointment a mini FDR, and if they are told any privileged information with or without prejudice information, then they can no longer have any further substantive involvement in the case. So far as I understand it, it has been in a tiny minority of cases that has happened. But
I have to say, I mean, despite what that guidance says, I've never had a judge who's been faced with a case that's come back to the court after a failed private FDR. And as I say, there are relatively few that go to private FDR that do fail, because most of them do actually settle. But those that have, certainly in the early days, maybe 3-4 years ago, there were a few judges saying, well, no, we're going to still do it properly in the court process. But certainly in the CFC and the courts that I tend to go to, judges have accepted the parties have had a go at it, and as long as they, as you said, they usually like to know who the private FTR judge was. But if it's a known London specialist barrister, generally that's regarded as being a tribunal that's robust and sensible. And the court leaves it at that. Says, right, that's the FDR done. If you've not managed to settle there, then we're just going to carry on with directions towards the final hearing without insisting on a second FDR, unless the parties say, no, actually we want one.
Yeah, so I agree with all of that, Andre, but I think the issue which is being teased out in the protocol is the fact that the court does have a duty under the rules to list an FDR, and as I say, in a tiny minority of cases that I am aware of, where further specific inquiry has been made, that is the way the way in which the judges have reconciled the relationship between a private FDR and the court.
I think in the moment, Rhys, I mean, this is largely academic, isn't it now? Because in the current circumstances, last week, Mr. Justice Mostyn issued the shortest and most pithy of all the guidance notes that we've had in recent times, because most of them, as you know, run to many pages, and we're getting guidance weary now. But his was only 6 paragraphs or so, and he very clearly in that said that parties should be encouraged to have their FDRs done privately. And they should be done remotely. And so I think at the moment, if there's been a private FDR and if the parties have asked for a private FDR, the courts are simply going to say, yep, get on with it. And I can't see them insisting on a court FDR as well.
I totally agree with you. I'm just setting out how we got to where we got to last week with Mr. Justice Mostyn's guidance. But you're absolutely right.
I think the issue now really is for those few cases that are still going to run through the courts, because if the parties can't agree to go to private FDR or can't afford to, which is one of the issues we're going to come to, the court process is still going to be the default. And I know anecdotally there's a number of courts that are currently still listing FDRs and are going to give them a time marking, because that's the only way that they can deal with a remote link up, that it needs to be between 11 o'clock and 12 o'clock, for example, rather than being blocklisted at 10 o'clock, which is as they've always been done. But I must say, I'm not sure how well the courts are going to be able to manage that.
No. Well,
you mentioned some of the issues. They are overwhelmed, and they're very much playing catch up in relation to the IT they've got. So we had a commendably complete and thorough document authored by Mr. Justice MacDonald, which was issued, I think, only on Monday this week. We're broadcasting or recording this on Thursday. Yesterday we had version 2 of that. And interestingly, version 2 contains a lot of commentary on some of the issues that the courts are having. So I think I can bring this up on screen and show you some of the passages within the document. So if I just bring that up onto screen so people can see it. So this is, as you see, this is the version 2 document, and the changes to it have been highlighted in red. So one of the bits
can I just chip in and say, Andre, that you talked about guidance fatigue. If somebody has not been tracking all the guidance that's been coming out in the last week, this is the most helpful document. This document and Mr. Justice Mostyn's document, I think, for money practitioners, are most definitely the most helpful.
Yeah, agreed. I mean, each division of the High Court has now issued its own guidance, basically, hasn't it? So if you practice in other areas, you would obviously need to look at the guidance for the Queen's Bench Division, for example. But this is, I agree that now the definitive guidance to be used in the family court, with the addition of Mr. Justice Mostyn's short practice note, which applies to the Financial Remedies Court. But you can see from the note here that there was a section that dealt with judicial access to a range of communications platforms, because the court was scrambling around to try and find what options are available. And you can see, even since the note was done on Monday, clearly the feedback has come back to Mr. Justice MacDonald about some of those issues, and he's fed into the document issues they've identified. For example, I've highlighted the fact that not all of the machines that the court service are using are open in the sense of having a operating system and connected up to a network which allows them to access anything as you and I do from our work machines at home. As a result of which, although they can use Skype for Business, they're not able to use other platforms such as Zoom, which is what we're using for recording this meeting on. Skype for Business has created a problem where if they're using dual screens in court, it seems that's having some effect over the audibility and the audio working. Judges who are using Skype for Business, or indeed any other platform, if they've only got access to one screen, are not able to access the e-bundle at the same time as using the video conference, which is obviously a challenge, because it seems that many judges are not set up for home working in the way that many of us have perhaps been doing for years already. Or certainly aren't set up for multiple screen use if they've always been used to using paper. And there's also just a general issue for part-time judges accessing the right equipment, because they haven't got court service issued laptops and computers. Yeah. And they've also raised the issue at the bottom here, which I'm sure many other people are experiencing as well, that if you live on a fast broadband connection, fine, you should be able to deal with all these services quite well, because Zoom doesn't use a great deal of bandwidth. But if you live out in the sticks, a long way from the exchange, you may be on a very slow exchange, which will make video conferencing very difficult, if not impossible, to use. And then finally, there's the point about the fact that many judges are simply not IT literate and are going to be struggling to catch up with all of this. So although I agree with you in your sentiments at the beginning that the courts are clearly motivated to do the best that they can and to continue to service the needs of litigants going through the court, they are going to be very stretched. And I agree with you that things like private FDRs are likely to be the alternative to the court FDR, just because the courts are probably going to struggle to accommodate them.
Yeah. So I think the IT capacity is a profound issue. And, we've been seeing lots of courts being closed in the name of a brave digital future, which is not yet upon us. So the timing is unfortunate. But you and I are in different locations having this conversation now with very easy to set up in Zoom. And of course, in Zoom, you can also create your breakout rooms so that people can have private rooms to speak in. So we'll come to that in a moment. Skype for Business, the court's main facility, has limitations. And there's a further problem. Many practitioners are on Office 365, and Skype for Business is a product which is going to be closed in a short period of time. And what Microsoft have been doing for a long period of time is trying to get people away from using Skype for Business by nudging them onto their new product, which is called Teams. And one of the ways in which they've been nudging people onto Teams is degrading the capacity of Skype for Business. And therefore, if you've got Office 365, there's all kinds of anecdotal accounts of people really struggling to be able to access a functional version of Skype for Business, where you can invite people. A really handy tip, which I've seen in some guidance, which has been put round by the FLBA, is that there is a link, which I tweeted yesterday, I think, which allows people who have struggled to download a completely functional version of Skype for Business. You can have a web scheduler. So if you go to this link, even if you haven't got a fully functional Skype for Business, you can still invite people to a meeting. So that's a really handy little tip, but it just sort of underlines the difficulties that we're having with accessing the court, that you've got to sort of know these sort of tricks and traps in order to be able to even get through to the court in the first place.
Yeah. Well, I mean, we're going to be at 36 using Zoom, because every member of Chambers has got a Zoom license that Chambers has provided to them many years ago now. We've had this for a couple of years now and used it for video conferencing for quite a while. So now it's finding its legs, and so it's very easy for anyone to use, because if we set it up, and it'll be whoever's hosting it as the early neutral evaluation judge, the private FDR judge, to set it up, we'll simply send a link out to the participants in it. All they will need to do is click that link. They don't even need to download any of the Zoom software. They don't need to have a Zoom account to do it. The person who's controlling the meeting, but we have a screen where we can, as you say, share documents, and we've already demonstrated how we've been doing that, which is very useful. Anyone who's using it can use that function, which means if you're the advocate and you have a document which the judge doesn't have, such as a photograph of something, and you want the judge to see that, that can be demonstrated and shown to everybody at the same time by the share screen function. You can do the same with schedules or other documents that you've got open and you want everybody to look at the same time, which may well come into its own even if we're doing trials through this medium in due course. So this is certainly software that we think works really well, and it's probably superior to any of the things that are being offered by the courts at the moment.
Yeah, certainly. Just moving on, if I may, you mentioned about being able to choose a evaluator or private FDR judge who the parties are agreed upon. Do you have any observations about the kind of characteristics that a good private FDR judge has?
Well, clearly the ones that you and I have. I mean, ultimately, I think it flows from what the purpose of the private FDR is. It's to give an indication to the parties, which the parties have the confidence to feel is a fair outcome, which they can work with and settle somewhere either dead on what the indication is in the ideal case, or within the parameters that indication is given. So I think clearly the most important characteristic is there's got to be somebody who is clearly competent and is sufficiently experienced and knowledgeable in the area of law to give the party the confidence that what that person is saying is a good indication of what's likely to happen if their case goes all the way to a final hearing and is decided by a judge in court. I mean, beyond that, it's to an extent there's a little bit of horses for courses, isn't there? Because each case is different, and the attributes or the skills of the particular private FDR judge that you want are going to vary from case to case. If it's a very technical case involving specific issues like pensions or trusts or companies, and clearly you're going to look for somebody who's got the expertise and the experience in those areas. If it's an issue which is purely binary in terms of there's a point of law on which the case will turn, which is actually quite rare, isn't it, in financial remedies cases? But let's say it is that sort of case. In those sorts of cases, you really want somebody who's just a legal expert, can give a view, and the bedside manner that person has is probably less important, because it is just a judgment on whether one party is right or the other party is right on a matter of law. But those aren't normal financial remedies cases. Most financial remedies cases are far more evaluative. There's far more discretion that dictates what the outcome is going to be. So you also need somebody who's got those softer skills, a little bit closer to maybe the mediation skills, to be able to understand how a settlement process comes about and to help the parties even on a psychological level come to the position where they can settle the case. And so to that extent, it's about finding somebody who is able to listen carefully to the case, make sure both parties feel they've properly had their cases listened to, is able to explore the issues in the case in a challenging way, polite, courteous, yes. There's no room for bullies and browbeating in this business, but is able to challenge and probe the propositions that are being put by either party. And so at the end of that whole process, even if somebody has put their case to the evaluator and the evaluator doesn't agree with them, they know that they've gone out and had that evaluation done on the basis of a full hearing, a proper hearing, and a proper consideration of all the issues. So I think that's what it really boils down to. It's that sort of package of skills.
Yeah. I think also there's more space in a private FDR for further indications to be given. So one appreciates the pressure, even in normal times, that a court is under. But sometimes a judge may give an indication that isn't perhaps what one side would have wanted to have heard. And they want to say, well, that's based on a particular view. But if this particular fact changed, or you took a different view about this fact, would your indication change? And asking for sort of different different types of indication depending on A or depending on B or C.
Yeah.
And my experience in court is that sometimes a court finds a request for them to sort of go back over their indication as some indication of impertinence, where in fact it's not impertinence. You're trying to explore all angles in the case and to make sure that the client who is sat behind you is seeing that absolutely every base is covered. And I think in the private FDR context, there's the space to do that more easily.
I agree. And I think that comes to but there are two slightly contrasting attributes that the private FDR judge has got to have to accommodate that. Yes, they've got to have the flexibility of mind and the humility to perhaps accept that an indication that they've given earlier isn't written in stone and needs to be reevaluated. But by the same measure, because we all know the games that go on within negotiations and private FDRs, they've got to be sufficiently robust to stand up to somebody who's just trying to push them and bully them into changing their indication. And so you need to have that as well, because there's nothing less helpful than an FDR judge who's given a clear indication and then for no apparent reason then seems to backtrack on it, because that's taking away all the ground that's been built up.
Yes.
But of course, I mean, all of this unfortunately comes at a cost, doesn't it? I mean, there is an issue that has to be addressed, and we can't get away from it. Parties are going to have to pay for somebody to do the job that they don't have to pay the judge to do in the normal course of things. I mean, broadly speaking, I mean, what sort of sense do you get as to what this costs?
Well, of course, barristers aren't supposed to, are we? Because we give no thought whatsoever to that, because this is merely a calling, and that we should direct all inquiries about such a grubby thing as money to Danny or to one of our other clerks. But as you ask, and as we're in exceptional times, I think it probably is helpful to mention. I think it would be fair to say that a conventional bracket for a senior junior, it would be between, for a one-day private FDR of some complexity, somewhere between £3,000 and £4,000. And there may be some very successful and busy juniors who are a little bit more than that, and there may be some who are willing to trim their fees in the circumstances. But I would say that is the bracket that most senior juniors would be operating in for a full day Rolls-Royce private FDR. That, of course, would be sort of £1,500 to £2,000 per party, and seen in that context is perhaps a very small slice of their overall legal spend.
Yeah, I mean, I think as a general sort of rule of thumb, I've always thought that most private FDR judges who are barristers tend to charge a similar fee for doing the private FDR as a evaluator as they might charge for doing the private FDR as an advocate. So yes, the fees that they charge as an advocate is often a good indicator of what their fees are as a private FDR judge.
I'd say that's very helpful, yes. But in these difficult times, there may be other models out there which haven't yet really taken on. I know that you and I have discussed and are willing to offer, and I don't use this word pejoratively, quick fire private FDRs. So rather than paying for a private FDR evaluator for the day, you could book one for, say, 2 hours. And I think that the bracket there would be significantly lower, and the parish, if I can put it that way, would be more in the region perhaps of £1,000.
Yeah.
And that would bring the benefits of a private FDR, albeit on a time-limited basis, to be more available to people who perhaps wouldn't be able to pay the higher fee for a full day.
Yeah, yeah. Well, I'm just looking on my screen here. We've now got a set of rates for 36Family members who are doing private FDRs, and they're quite a range of people in terms of expertise and experience and call. But the rates for what you describe as the quick fire, which I think we're offering a 2-hour fixed appointment, effectively. Clearly, there's some flexibility around that, but if people have got other commitments in the day, it's the 2-hour slot that is when the video link will be available. There's always the option to come back in a little bit later on, but that'll be subject to other commitments that we have. And the rates for that vary for between about 500 at the lower end for more junior practitioners, up to 1,000 at the upper end. So you're talking about potentially getting a private FDR judge at a junior level for a relatively straightforward case, with each party paying only £250 each, which is not a million miles from the cost that they'd be incurring going to court in any event.
No. When we in other forms of ADR, I'm thinking particularly mediation, a long-standing practice of signing an agreement, and then also arbitration, where of course it is absolutely a prerequisite to have a contract in place to actually constitute an arbitral tribunal. I wonder whether you'd be able to give your observations about how agreements do or don't happen in the context of the private FDR.
Well, in my experience, they very rarely happen. I don't think I've ever done one as an advocate where the private FDR judge has requested a written agreement in advance. I think it would be helpful in many cases if people did, because one of the problems that can arise in a private FDR, of course, is that the judge doesn't actually have any coercive powers. He's not a judge. He is just another barrister in the party all there voluntarily. So unless you set out some sort of ground rules around what the process actually is, there is always a danger that somebody just walks away from it or deals with it in an inappropriate fashion. So having some sort of written agreement at least ties people in and gives everybody a set of rules by which they can operate. And certainly in terms of without prejudice, confidentiality issues, who attends, issues such as that, having an agreement in place, I think, would be a good discipline to have. So yeah, I mean, I personally think that they should, and I know you share that view because you and I both have worked on a draft that we do offer to people.
Well, as I'm a mediator as well, I'm just astonished when this market started to develop, that people were just hosting these meetings on the assumption that the without prejudice privilege and confidentiality will apply. Now, it may well be that they can be implied as a matter of law, but such is the importance of those express terms being agreed in a mediation. It strikes me that perhaps some very excellent private FDR judges who don't perhaps aren't mediators have perhaps missed a trick in not insisting that those documents, those clauses are actually set up, because they really are quite important to make sure that those things are hammered down, and that's particularly so in the remote context. You found it, well done. So here's our private FDR agreement. We've called it an early neutral evaluation agreement. A private FDR is essentially early neutral evaluation, and I think
the reason we've used that terminology is because we use these in Talata disputes and disputes that are outside the financial remedies context as well, don't we?
Yes. And the document has many similarities with a mediation agreement, and just has clauses which practitioners would be very familiar with. One of the issues, of course, if you're doing a private FDR properly, is that they are confidential, and there is provision within this agreement for confidentiality and for information contained within the FDR not to be shared outside of the meeting. And anyone who's present at the meeting, even if they're present remotely in the room with a husband or a wife, would have to sign. This document was drafted prior to the crisis, and I've seen some guidance which is out there in I think in Mr. Justice MacDonald's and perhaps in other guidance as well, that there should be an indication given at the start of the meeting or the hearing as to who is actually present, and it would make sense for that kind of clause to be replicated in this document, although it isn't in the one that we're showing presently here. So I think if you're wanting to engage a private FDR tribunal, a document such as this, and there's no magic in this one, there's many different ways in which that they can be put together. Something like this, making express those things we take for granted, I think is important, and it also keeps some control or more control in the situation, given the remote nature of the hearing.
I mean, I've given some thoughts, and it may be in some cases it's appropriate to do it. Is to you could include terms such as the parties agree that no one will leave the private FDR until the private FDR judge, the evaluator, indicates that the process is closed, which potentially creates a little bit more like the court-based scenario where the parties can't just walk out before the process is finished. Of course, it's not going to be binding on the day, but if it's written down and parties are signed to it, it just provides a little bit of extra leverage. And there is also potentially scope for the parties to agree that they agree that if the private FDR doesn't succeed in a settlement, there might be consideration given to the private FDR judge at the end of the day, indicating appropriate directions, if for example, if the parties want that. Those are probably optional clauses that can be built in or added to an agreement with following discussion with the parties if they want to do that. But those are refinements that you can build into it. There's no single template, is there, for private FDRs? It's a flexible process which can be adapted to be used in the right way for the particular needs of any particular case.
Okay, so I think we're getting to the end of what we really want to say now. But can I just ask, how, for someone who's not done a private FDR before, and let's talk about it not remotely to start with. What would you expect? How do they work?
Well, the day runs pretty much as it would do at court, except that it's not at court. So it'll be hosted in the chambers of the barrister who's hosting it, or at some other venue that's been agreed. In all probability, there are going to be 4 rooms. There'll be a room for the hearing to take place in, a room for each of the parties to use as their conference room, private from each other, and in an ideal world, there'll be a 4th breakout space, a 4th room, where the advocates can go and speak in order to negotiate privately away from everybody else. If there are only 3 rooms, then another space might need to be found to use that. And then the day proceeds pretty much as it would do at court. The parties will probably have some pre-hearing discussions and negotiations. If they don't manage to make any progress from those, they're likely to start the hearing. If they're making progress, the private FDR judge is likely to allow them time to discuss further to see if they can reach a solution, but always keeping an eye on the clock, because if you don't get an indication until mid-afternoon, then obviously it's rather late then to negotiate after that. So trying to get an indication in the morning is useful. But then if they haven't, following that hearing, following the discussion, haven't managed to reach an agreement, they'll have a hearing. Both sides will present their case. It's likely to be a good deal more thorough than the hearing you would have in court if you're doing the Rolls-Royce full-day service, because there'll be more time to deal with it. There'll be more submissions. There'll certainly be a lot more questions, I would imagine, from the tribunal to each of the advocates. The parties in a particular case might possibly be engaged as well by the FDR judge directly, if that's helpful. And the private FDR judge, in everything other than a very straightforward case are likely then to want to take a bit of time to collect their thoughts after the hearing, and will then give a reasoned indication. So rather than just putting a finger in the wind and telling you the way it feels, they're likely to do some proper calculations, maybe even give you some documents that set out in written terms what their indications are on the main points, with the calculations and support, maybe with a Duxbury calculation if you're talking about a case where there's going to be capitalisation and maintenance. The party will then withdraw, they'll carry on negotiating, and as you said earlier on, they can come back in and out as many times as they need to on further points as they arise throughout the day. So very similar to the court, but obviously with the advantage that you've got your arbitrator, your private FDR judge locked into just your case for that period of time.
I think one of the things I've really appreciated about private FDRs as well is that you're not being tipped out into the street at 5 o'clock. And one knows that just in the ordinary dance of a negotiation, it's quite often the case that the serious negotiating isn't happening until 3:30 in the afternoon. And then if you can get to heads of agreement, quite often at that point parties say, well, we'd like to hammer this out into an agreement if it's at all possible. And I found it singularly unhelpful to get to 5 o'clock and to be tipped out into the street by the court staff, and then to have to decamp either to a solicitor's office if there is one nearby, or even on occasions into a restaurant or something like that.
Well, yeah, and Bognor Regis Wetherspoons always sticks in my mind. But I mean, how do we recreate that? I mean, don't mean the Bognor Regis Wetherspoons, but how do we recreate the process remotely?
Well, as you've indicated, 36 primarily will be using Zoom. This presentation that we're doing hopefully gives some indication of the quality of the transmission and the way in which it's easy to communicate with one another. What would happen is that in advance of the meeting, the parties and the advocates would be sent a link so that they can join a meeting which is hosted by the private evaluator. The evaluator can then give the parties space within the overall meeting to go into private rooms to have discussion, and you can have private rooms for the parties to discuss things confidentially with their lawyers, and you can also have a digital corridor, as it were, or breakout room where the barristers or advocates or solicitors or whoever they are who are actually representing the parties can go and have further negotiations, not in front of the parties, which one appreciates is the usual way of things in court. Now, I know, Andrzej, you have some views about that. We've used the breakout rooms in Zoom, and they do work. The person who is hosting it can't be a nosy neighbour and put their digital glass against the wall and listen to what's going on. But there is some concern about people's ability with IT, and I wonder whether you'd just like to mention that.
Yeah. The Zoom system is actually very robust, and as I understand it, the whole thing is encrypted. So if you're in a private breakout room, you are in that room, and there's absolutely no way that somebody is going to come into that without you knowing. But I'm slightly concerned always about holding privileged discussions in a environment which I'm not in control of, and there is, particularly with IT, always the possibility that somebody slips up and lets a connection link somebody else to it, or in some way somebody else taps into a connection that's been set up incorrectly in the first place. So although I think the breakout rooms could work really, really well, personally I feel more confident if I'm having privileged discussions myself with my clients, professional and lay, I would probably want to do that within a forum that I'm controlling. And whether that's done by way of a separate Zoom conference, which you set up, which you could clearly do. You could do it by way of a FaceTime link or whatever medium you want to be using as the lawyer. I think giving some thought to how you manage that is probably well worth doing. And don't just assume that just because the breakout rooms are being offered to you, that's necessarily the way you want to do it. You may want to decide actually to keep control of the process yourself. And I know anecdotally, a few people in chambers have already been holding hearings remotely using Zoom, Skype for Business, and other similar forums. And they've been using WhatsApp as a separate group chat between themselves and their clients to take instructions during the hearing, or you can set that up in whatever other mechanism you want to. So just be aware of the fact that because you're using an environment that is different to the norm, where you can look around in the courtroom, you see exactly who's there, or you can open the door to a conference room and see who's standing outside. It's not always obvious within a digital platform exactly which screen is open to who at any particular time. And particularly if you're not so familiar with it, you could easily get yourself into a bit of a pickle.
Yes, you don't want to be overheard saying, well, I advise you to settle at all costs.
Exactly. That's exactly the wrong time to be joining a general plenary session, isn't it?
So we're really coming to the end now, and yeah. I know that we intend to come back in a week or so and talk about some of the legal issues which are arising in the financial remedy context. So I don't propose that we're going to dwell on those much at all now, but I'm just interested because I've seen people asking this on Twitter. It's a big question at the minute. Cases which have already gone on, is what is happening now a Barder event? And if it is, when did it become a Barder event?
Well, I mean, that's a really interesting discussion that I think we will need to deal with properly. I mean, the times that we're dealing with are unprecedented in many ways, but they're, as with so much in life, there's usually some precedent that's not entirely dissimilar that you can find somewhere in history. And only 11 or 12 years ago, we could, of course, had the financial crash, where the courts were dealing with similar circumstances where people's businesses and livelihoods had been wrecked almost overnight. As you'll know, in the Meissen case, where Mr. Meissen settled his case on the basis he was going to buy his wife out of a business, and the business value then collapsed after the financial crash, and he tried to go back and reopen on the basis that that was a Barder event. He was given fairly short shrift on the basis of the case law in Cornick and the other cases since Barder, on the basis that a change in valuation is not something which is utterly unforeseeable, and therefore, if you don't choose to share an asset on a Wells and Wells basis, you run the risk that if it collapses in value, you will be stuck with that. Now, whether what we're facing at the moment is of a different magnitude and therefore of a different category is an interesting debate. I think we'll probably explore that next week or so once we have a little bit more clarity as to what's going on in the world, and perhaps are better informed to do that. 2
points I'd like to briefly make, if I may. One is, alongside Barder, one shouldn't overlook the barrel jurisdiction and the capacity of a judge to change their mind before the order is sealed. And although it's generally referred to as the barrel jurisdiction, there was, of course, the case that went to the Supreme Court a few years ago, where where the Supreme Court considered whether or not a judge could simply change their minds after having delivered a draft judgment, and there's no test of exceptionality, and that's something in those cases which you settled 10 days ago, but you yet to have the sealed order, is something you might like to think about. I know, Andrzej, you are a supremely self-effacing individual who wouldn't dream of mentioning a certain book, but so I'm going to do it on your behalf. One of the best books I have in my library is Unlocking Matrimonial Assets on Divorce. Tragically, it stopped at the 3rd edition. And I know there's a lot of lawyers out there who really appreciate what you have to say in this book. But what is very useful within that book is chapter 27, which was written post the crisis 10 years ago, using financial remedy orders at times of economic uncertainty. So I'd suggest for those of you who have an old copy of this, you get it out and dust down chapter 27. And for those of you who don't have one, I'd get on to Amazon pronto and see whether or not you can get your hands on one.
I think it's available as an ebook, so that may be the easiest way to get to it in these days of social isolation. But thank you for that, very much for that, Rhys. Can I suggest maybe you and I pull up our armchairs around the fireplace again in a week or so, pour ourselves a dram of whiskey, and we discuss those issues?
Excellent, yes.
All right. Thanks, everybody, for listening. Cheers.